Pending appeal, the Queen on the application of Nunn and the Chief Constable of Suffolk Constabulary and another.
Lord Hughes will explain the decision of the court.
During a police investigation, and whilst there is pending either the defendant's trial or his appeal, there's no doubt that the police and the prosecution bear a duty of disclosing to him anything in their possession, whether they are intending to use it themselves or not, if it might either undermine the case against him or assist him in any way in his defence. The issue in this appeal was the extent of any such disclosure duty after the defendant has been found guilty and any appeal has failed. After a 6-week trial before a judge and jury, Mr Nunn was found guilty of the murder of his girlfriend. She had disappeared and had been found 2 days later by a river, mutilated, burned, and arranged in a sexually humiliating position. The jury heard evidence that Nunn had quarrelled with her on the night that she disappeared, that he had stalked her in the past, that he had surreptitiously got hold of a key to her house, and that he had been seen carrying something the size and shape of a body out of her house in the small hours of the night before she was found. He denied that he had been anything to do with her death. He said there hadn't been an argument and the identification of the person who removed the body was wrong. He suggested that one or other of 2 different boyfriends of the lady might have killed her. His case was rejected by the jury, but he continues to deny that he is guilty. Through new solicitors, he has made a series of requests that the police re-examine the evidence. For example, he wanted to know about the dead woman's finances, which hadn't been an issue in the trial at all. He wanted to have the whole of the forensic scientist's work reviewed by a new forensic scientist, and a lot of the samples which had been taken retested, although there hadn't been any significant dispute at the trial about the scientific evidence, and the judge had told the jury that it didn't really add to the case against him. Likewise, he suggested that a serial killer from a town not far away might have killed the lady. The police answered his question about the deceased's finances, and later they also provided reasons why this killing didn't seem to fit the pattern of the serial killer from the nearby town. But what they declined to do was to keep going back to the evidence, which had now been archived, in order to enable the defendant, in effect, to have a wholesale reinvestigation of the case undertaken. The issue in the appeal was whether the law allowed them to take that stance, or whether, as was contended for Mr Nunn, they remained under the same obligation of disclosure after the conviction and appeal as they had been while the case was ongoing. The court's unanimous decision is that the duty of disclosure does not continue unaltered after conviction and appeal. The reason for the duty of disclosure is to enable the trial to be fair, to enable the defendant to take any point in it that he wishes. Up until the end of the trial, he is presumed innocent, and he is entitled to defend himself in any proper way that he wishes to. But once he's convicted, he's no longer presumed innocent, but rather proven guilty. There remains a public interest in any flaw in his conviction, if it exists, being exposed, because no one ought to remain convicted if the conviction is unsafe. But there's also an important public interest in the finality of proceedings, for the sake of the family of the deceased, for the sake of witnesses, and because the finite resources of the police ought not to be diverted from new current investigations into an indefinite reinvestigation of concluded cases. There is a duty of disclosure after trial and appeal, but it's more limited than before. Its extent, the court holds, is properly set out in guidelines issued by the Attorney General for those who handle prosecutions. The police and prosecutors must first provide the convicted defendant with anything new which comes into their possession if it might cast doubt on the safety of the conviction. Similarly, they must cooperate in further inquiry if it be shown that the inquiry has a real prospect of revealing something which makes the conviction unsafe. They are not, however, under a duty to cooperate in speculative reinvestigation simply because the defendant does not accept the verdict of the jury. That conclusion is supported by experience in other common law jurisdictions as well as by the English authorities. In England and Wales, and indeed in Scotland as well, there is also a separate specialist body charged with investigating possible miscarriages of justice, the Criminal Cases Review Commission. This independent body has the power to refer a concluded case back to the Court of Appeal for a second appeal if it thinks that the conviction may be unsafe. The court's conclusion in the present appeal is that the existence of this body is another reason why there is no occasion for the prosecution's duty of disclosure to continue unaltered after conviction and appeal. The court, however, makes it clear that if there is a proper inquiry on a topic where there is a real prospect that the conviction might be shown to be unsafe, the prosecution and police ought not to wait for an approach from the Commission, but should cooperate in the inquiry. There have been several examples of this being done in cases in the past. In the present case, the nearest that Mr Nunn could assert to an inquiry of that kind concerned one particular sample taken from the body of the deceased. It included bodily fluids. They'd been tested for DNA at the time of the trial, but analysis techniques have since then become more discriminating. If retesting would have a real prospect of demonstrating that somebody else killed the deceased, then the continuing duty of disclosure would apply to it. The Divisional Court of the High Court had held that on the facts of this case it would not. It had been known at the trial that the fluids could not originate from the defendant, and the various accidental and other ways in which it might have got there had been fully investigated. Moreover, the new forensic scientist advising Mr Nunn had expressed the view that retesting would not eliminate him. However, a request of that kind, the court holds, is to be dealt with according to the principles which are set out, whether the application is made by solicitors for a defendant or the inquiry is initiated by the Commission.
Court is now adjourned.